Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy podcast. Today on the podcast, we are going to be talking about 5 ways to procedurally attack the admissibility of the breath test in North Carolina, attacking the intoxilizer. That's the focus of the podcast for the day. So excited to get into that. Before we do, we are currently about 2 weeks into January, 2 weeks into the new year. It's 2021. Hopefully you have started the new year off on the right foot and you have started the first quarter of 2021 off on the right foot. A couple of episodes back, we talked about the importance of reviewing the game film and getting kind of ready and prepped for 2021, setting your goals for 2021, and success in 2021 begins with success in Q1 of this year. And so again, we're early on in Q1, so there is still a lot of time to tackle the goals that you have for this quarter. But what I wanted to spend just a couple of minutes talking about before we dive into the substance of today's discussion on attacking the breath test was just to encourage you to really push yourself at the beginning of the year. If you start things out on the right foot, if you, as they say in football, set the tone, right? In the kickoff moment, showing the other team, your opponent, that you're going to be playing physical and rough and tough and hard the entire game by setting the tone early on, you're going to succeed in getting into the mind frame of your opponents. And the same is true in terms of setting the tone on your own end going into 2021. So in terms of the importance of starting 2021 off on the right foot, a study from 2015 found that NBA teams that won the first quarter of a game, that scored more than their opponents in the first quarter, went on to win the game 68% of the time. So in terms of being able to recover from a bad first quarter, it is possible. You can still win the game if you have a bad first quarter, but it's very difficult. And it's a lot easier to win the game if you have a great first quarter. And so that's why it's so important to have a great first quarter. In 2018, another study was done, this time with the NFL, and it found that 69% of teams that won the first quarter went on to win the game. So right up there in the high 60s at the elite level of professional sports, teams that are winning the first quarter have a much higher chance of winning the game. If you win the first quarter of this year, you're going to have a much higher chance of reaching and exceeding the goals that you have set out for yourself for the entirety of 2021. So work hard during the first quarter of 2021, set the tone, get things off on the right foot. So let's go ahead and dive into what we're going to talk about today, which is some procedural ways to attack the breath test. Before we get into the 5 ways, the 5 procedural ways, and there's more than 5. I'm just going to go through 5 today. Take away from this to look for these 5 issues anytime that you have a DWI that involves a breath test. Make sure that the state has checked the box on all of these items. But before we get into that, most of what we're going to be talking about today is based on implied consent. You really cannot have a breath test that occurs without consent. If a person doesn't give consent to do a breath test, they cannot be forced to blow. They can be forced to give a non-consensual blood draw through a search warrant to get the person's blood, but they can't be forced to do a breath test. So all breath testing is done in North Carolina, and as far as I know, every other state, by consent. So if you have a breath test, you're operating in the consent mindset. Now, in North Carolina, we have an implied consent theory that by driving on the roadways, if you are suspected of being impaired in driving, you are, in theory, giving your consent to then be requested to give a blood, breath, or urine sample, and that you are going to do that. And that refusal can then be used against you potentially in court. But just because there is an implied consent statute does not automatically mean that every time that somebody is requested to do a breath sample, that it is being done by consent. And I like to read to you from the North Carolina Supreme Court's decision in State versus Romano. This is a case that I argued at the Superior Court level, so I'm very familiar with this case, but kind of beyond the issues that we were primarily focused on in State versus Romano at the Superior Court level, the North Carolina Supreme Court talked a lot about consent in that opinion. And so I just like to read this, and I think this is a really good place anytime you have a issue with a consensual taking of blood or breath. This is a great place to start. This is a great place to kind of lay out the case law. As we've talked about before, always present a copy of the case law that you're arguing to the judge. Let them read it with their own eyes, digest it, ask questions about it. But in State versus Romano, the court says, and so I'm just going to read from the opinion, treating subsection 20-16.2b as an irrevocable rule of implied consent does not comport with the consent exception to the warrant requirement, because such treatment does not require an analysis of the voluntariness of consent based on the totality of the circumstances. Whether a consent to a search was in fact voluntary is a question of fact to be determined from the totality of all circumstances. And that is from the court quoting Sheckloth, a U.S. Supreme Court opinion. Going back into the Romano opinion. Further, the state has the burden to prove that consent was in fact freely and voluntarily given. Consent is not voluntary if it is the product of duress or coercion, express or implied. A court's decision regarding whether a suspect's consent was voluntary is based on a careful scrutiny of all the surrounding circumstances and does not turn on the presence or absence of a single controlling criterion. The standard for measuring the scope of a suspect's consent under the Fourth Amendment is that of objective reasonableness. So that is a great place to start off anytime that you are arguing the implied consent exception to the warrant requirement. Where the state is trying to get breath testing in, you're trying to keep it out. You're saying that the only way that the state can get this in, since they did not have a warrant judge, is through a valid exception to the warrant requirement. Here they are arguing that there is a implied consent, that there is a consent exception to the warrant requirement. Let me explain what the court has said is consent. Just because the implied consent statute exists does not mean that a breath test was consensually given. So just because somebody blows on the device does not mean that that is by consent. If you have a situation where the person has had some sort of medical issue or head injury, doesn't understand what they are doing, doesn't understand what they are reading, that is an issue that should be looked at when the state is arguing that the breath test was consensual. If you have an officer that is telling your client, if you don't blow, I am going to get a warrant to draw blood, and we're going to hold you down, and it's going to be miserable, and you're going to hurt. Like if the officer gets coercive with how they are framing the person's requirement to do the breath test, argue that in terms of whether or not consent was freely and voluntarily made. Doesn't mean that, in fact, the officer has to tell the person under the rights form of 20-16.2 that if they don't blow, they may try to get a blood test and they may try to get a chemical analysis completed without consent. So they're allowed to do that. But if they start getting into coercive language, or the encounter is such that the person is acting under duress when giving a breath test, argue that in terms of saying this was not a consensual breath test. It is very clear under Romano that the mere fact that the implied consent statute exists is not enough to automatically allow a breath test in each and every case. It is the state's burden, as Romano indicates, to show that the consent was freely and voluntarily given, informed. So argue that. Set the stage with that language. Now, in terms of the 5 ways to attack the breath test, these are, again, not an exclusive list. We're just going to talk about 5 ways today, but these are things that come up frequently in cases that I've had, and something that should be looked at on each and every DWI case. Don't miss these opportunities to keep the breath test out of evidence. If the state's main evidence, and it normally is, if the state's main evidence is that breath test and they cannot get that number into evidence, the chance of beating the DWI now goes up significantly. These are easy ways to get the breath test kept out of evidence, easy ways to make an argument that the state should not be able to introduce the number. So make sure that when you look at the case, you're looking for these specific issues because they pop up, they arise a lot. So the first issue is the pre-test observation period. So basically making sure that there was an observation period kept. Under 20-16.2, there is an observation period required, and the North Carolina Administrative Code defines what that observation period looks like. And a lot of the language in 20-16.2 is kind of similar and mimics what is in the North Carolina Administrative Code in terms of that, what the observation period looks like. 10A NCAC, North Carolina Administrative Code, 41B period 0101 is where you will find the observation period defined. So if you're looking for a definition of the observation period in and of itself in the North Carolina General Statutes, you're going to have a hard time finding it because it's in the North Carolina Administrative Code. So go to the Administrative Code, look at the definition for observation period, and make sure that this has been kept. Now, normally the observation period is met simply by the officer stating on the affidavit, I began my observation period at X time, let's say midnight. I requested the sample, the first breath sample from the defendant at 12:16 a.m. Ergo, the observation period is met. That's it. That's the whole analysis, right? On the affidavit was the time frame that was listed in terms of the start time of the observation period prior to first breath sample being given more than 15 minutes? If so, on the affidavit, at least on the face of the case, the state has met its observation period. Now, you may have an extremely rare case where the officer didn't correctly input the time or did not know that they were supposed to do an observation period. That's going to be an extremely rare situation. But what you might see is if you get a copy of the officer's body camera or a copy of the intoxilizer room video, if that exists, then that is where the observation period, in my opinion, can definitely be challenged. If the officer leaves the room during the observation period has not been met. If they're not looking at the client, if they're walking around and they're on the other side of the room, the observation period is not met. And oddly, this is something that happens, I would say, extremely frequently on DWI cases. The officer is in there. He reads the rights to the person. He starts his 10 to 15-minute period observation, but then proceeds to walk around in the intox room. Officers will leave the intox room. They will turn their back to the client for minutes on end. That's not an observation period. The purpose of the observation period is to make sure that the person is not burping, spitting, putting stuff in their mouth, putting any type of, doesn't have tobacco in their mouth, all of these different things. If they're not watching the person, they can't make sure that's not happening. The whole purpose of the observation period is to make sure that that doesn't happen. Not that there's not just simply not an opportunity, but to make sure that it doesn't happen. And so if you have an officer that is sitting and kind of facing the defendant, but looking down at their notes and, making notes about the case or filling out their paperwork, whatever it might be, well, the observation period is still probably met in those circumstances. But when the officer gets up and leaves your client sitting there during the observation period, starts walking around the intox room, leaves the intox room, has their back turned to the person charged for minutes on end, that is a good basis to challenge the observation period. So you can also use that video to see if the actual time frame of when observation period begins and actual breath sample being taken is in fact 15 minutes. On the paperwork, it's very likely that's going to be 15 minutes, but you can verify that also with video. So look into whether that observation period is being met. Look at the preventative maintenance records. So there has to be preventative maintenance done pursuant to, again, North Carolina Administrative Code, Chapter 10A, or Section 10A, Chapter 41B, period 0323. Preventative maintenance must be done. You can also look at North Carolina General Statute 20-139.1. So look at those to see whether or not the required preventative maintenance that needs to be done on the intoxilizer has been actually completed. Make sure that it's been done correctly. Number 3, make sure that if there is a re-advisement required, that has happened. Now, this is kind of more of a hybrid where there's both blood and breath testing. But there have been times, and I've seen this frequently in my practice, where the officer requests a breath sample. The officer reads the person their rights under 20-16.2, provides a copy in writing. Person either refuses the breath test or is not able to give a sufficient sample. And then the officer requests, so by consent, not by warrant, by consent, subsequently requests a blood sample. If they do that, they have to reread the rights under 20-16.2 and re-provide a copy to the client in writing. So there is a re-advisement required. This is State versus Williams that makes this clear. That's 234 North Carolina App 445, 759 Southeastern 2nd 350. Look at State versus Williams and look at 20-16.2. State versus Williams is very clear that if there is a breath test requested by consent, and then the officer subsequently requests by consent a blood draw for whatever reason, the entire re-advisement process must occur before the blood test. So the fact that they have legitimately done the rights advisement prior to breath testing does not allow them to go straight to blood testing. So make sure that there has been 2 advisements done prior to the blood sample being taken, or you can request that the blood sample be suppressed. So that's item or attack point number 3, procedural attack point number 3 based on State versus Williams. Kind of piggybacking off of that, because we kind of just talked about it, but point number 4 is that the officer must provide a copy both orally, or must communicate the rights under 20-16.2 both orally and in writing. Both orally and in writing, communicate to the person charged that they have been charged with an implied consent offense and read them the rights. So this, again, is not something that is going to be easy to determine whether the officer has adequately done this both oral and in writing presentation of the rights without some sort of video, body cam, dash cam, maybe intox room cam. You might see this on the body cam where the officer has read the rights but does not give a copy of the same rights to the defendant. Even if they give it to him right afterwards, they have to give them the copy in writing at the time they are making the advisement. They have to provide a copy at the time of the advisement being given. You might see this with blood testing at a hospital where person is in a hospital bed, officer sitting there reading, the person, doesn't have either use of limbs or is not, completely coherent from potential medical issues or whatever it might be. So if you can see the officer not providing a copy in writing of that rights advisement form, that is not valid consent. That is not going to pass the requirements of 20-16.2. So again, make sure that video shows client, if you have a copy of it, make sure that video shows that client has been provided a copy in writing as well as being communicated orally their rights under 20-16.2. And then finally, and this one is a little bit more rare, but again, worth knowing and making sure that it is correctly applied in your case, there has to be 2 tests within 0.02 of each other, or the breath test ticket is not valid. So if the person blows a 0.14 and then blows a 0.11 on the breath test, that is not a sufficient breath test. And in fact, if those are both taken on the same test ticket, those 2 different samples will not reveal a reported AC level. It will basically say at the bottom, kind of like almost an error message in the reported AC, not within 0.02 or something along those lines. But there will be a message that indicates that this is not a sufficient sample for the purposes of the test. So under 20-139.1B3, you have to have two samples that are within 0.02 of each other. Two samples within 0.02. So if you have the officer get a breath sample, then there's a number of insufficient samples, or there's a number of insufficient samples and then a breath sample, and the test times out, and the person has blown, again, let's say a 0.14, the officer restarts the test, gets another sample, and that comes back at a 0.11. And the officer says, I've got my two samples, I'm good to go. If they're not within 0.02 of each other, then it's not considered consecutive samples within 0.02. Now, the statute allows a little bit of fuzziness in terms of what a consecutive sample looks like. So in that same analysis, if you have a test ticket, 0.14, test times out, second test ticket, the first sample is a 0.11, second sample is a 0.14. Now you've got a matching of the two 0.14s. So under the breath testing requirements and the case law, likely the state would be able to get those two 0.14 samples as being within 0.02 of each other even though there was an intermingled 0.11. So even though there was a intermediary sample, the 0.14 and the 0.14 are going to be considered by case law likely as consecutive samples. There's a little bit of gray left that you could argue on that front, but the case law would definitely spin in that direction in terms of those being considered consecutive samples, that they don't have to be kind of exactly proximate to each other to be considered consecutive. So make sure that has happened. Even though I have seen that come up one time where there was two test tickets and the numbers were not within 0.02 of each other. So again, you may have like a dead ringer in terms of that being a good issue to argue in keeping out the breath results. The other way to use that 0.02 is to basically use that in an argument of diminishing the accuracy, the believability of the breath testing device. So because the statute requires that the two samples be within 0.02 of each other, I have argued many times at both district and superior court that 0.02 requirement is the statute's way of saying there is a little bit of error allowed within the breath test. There's no reason why somebody's BAC level would go from a 0.13 to a 0.11 within 3 minutes. Does not make scientific sense. It's because the way that breath testing works, you're basically not testing the person's blood alcohol concentration. You're looking at their deep lung sample. And so it is an estimate. The breath testing is an estimation of a person's blood sample by getting the deep alveolar air from the person's lungs. And so by requiring that there be two samples within 0.02 of each other, as opposed to just saying any sample that you get, if you get a 0.11, that's enough. You don't need to retest. Or requiring them to be the same, a 0.11 and a 0.11. The 0.02 requirement basically says we are okay with a little bit of inaccuracy coming from the breath test. We expect there's going to be a little bit of inaccuracy, but if it gets to 0.03 or more, that's too much. Now there's something going on with the machine, or there's not something trustworthy, but it's trustworthy. The two samples are trustworthy if they're within 0.02 of each other. Now, if you can lay that out and explain that, then when you're arguing to a judge or a jury about a 0.09 or a 0.08 reported BAC level, you can argue that is now within the range of error that is acceptable under the device. The device has an accepted rate of error of 0.02. It's perfectly legitimate for the first sample to be a 0.11 and the second sample to be a 0.09. It's perfectly legitimate for the first sample to be a 0.08 and the second sample to be a 0.10. And so if that's the case, then on any given sample, anything considered within 0.02 of that sample is a legitimate number according to the device. It's a trustworthy number according to the device. It's within the range of error that the device allows. And so use that 0.02 discrepancy to argue to a judge or a jury the lack of trustworthiness that is inherent in breath testing on a 0.08 or a 0.09 case, or even a higher number. Built into the device itself is an understanding and an expectation that the two breath samples, which are taken within moments of each other, are not going to be the same number. So use that in your closing. So that's it for today. There's, again, a lot more different ways to attack breath testing. Just gone through 5 of those today. Fight hard, work hard. In preparing for today, I reviewed something that I routinely go to, which is the Teddy's North Carolina DWI trial notebook, originally authored by David Teddy. This is the 3rd edition, which was revised by Andy Banzoff and Cole Williams. Really powerful book. If you do regular DWI practice and you are not, if you don't have a copy of that, elevate your game, elevate your DWI practice by going to the North Carolina Advocates for Justice website and getting a copy of that DWI trial notebook. It will provide a ton of insights to you on ways that you can attack cases, DWI cases. It has great statutory references, case law references, suggestions for ways to suppress various pieces of evidence on a DWI case. So go to that resource. Make sure that you have that if you practice DWI cases regularly. Hope you enjoyed the episode, and I look forward to speaking with you next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.